welcome back to Men's Day Out. Today we have a lawyer from Mumbai who is joining us, Ms. Kanupriya Kejriwal. Kanupriya is based out of Mumbai, and she also deals in cases which are based in Mumbai, Thane, Pune and Maharashtra otherwise. We recently got in touch with her with an order that we came across, and this was a very short-lived marriage which lasted only for 32 days in 2016. The woman left the house in 32 days and subsequently filed for maintenance once the husband filed for divorce. Now, in that case, the court in 2020 has rejected maintenance, and we'll not talk much about that case because the matter is sub judice. However, let's welcome Kanupriya and discuss the aspects of maintenance in short-lived marriages as general. Hi, Kanupriya. Welcome to Men's Day Out.
Hi, Arnaz. Thank you so much for having me. It's a lovely platform and it's a great opportunity for me to express my views here.
Thank you. So, Kanupriya, let's discuss about maintenance, interim maintenance, alimony in short-lived marriages. Now, within a few hours, we are all going to be in 2021. And, I mean, the struggle has always been for women to be empowered, to be educated, to be independent enough to sustain themselves in case something goes wrong in a marriage or even otherwise if you're unmarried. Now, how fair is it that, first of all, let me ask you, when you go to court, if you are representing the husband or the wife, what is the basic premise of maintenance? How do judges really analyze whether a person is eligible for maintenance or not?
Okay, so as I think most people already know, there is no straitjacket formula or there is no exact law in our country when it comes to maintenance. Like there are lots of countries which will sort of have a straitjacket formula, division of assets. Our country does not have that. Because of which, unfortunately, there is also a lot of misuse of the law. And also a lot is left to the interpretation of every sort of judge, and every case is sort of different. Having said that, I feel in my experience, what I've seen is that there are lots of factors which are taken into consideration while awarding maintenance, such as the number of years which are invested in the marriage, whether or not the couple have children together, whether or not there was a role played by the husband or his family to ensure that the woman is not working, in the sense whether there was some pressure from the husband or his family to say that she shouldn't be working, what the educational qualifications of both the husband and the wife are, what the lifestyle that they collectively led together as a couple was. And they also look into sort of the earning capacity. Even if you're currently not earning, what is your capacity, which obviously is governed by education with your past work experience, etc. So all those factors together, and maybe also whether you have other dependents like old and aged parents or kids from some previous marriage or something of that sort. So I think it's all of this put together that is taken into consideration.
Right. But, the pattern in which it works is, let's say there's a divorce petition which is filed and subsequently there is an application for maintenance. Now, the maintenance incidentally gets fixed before arguments of the divorce petition itself. So when you say the court is analyzing whether what role the husband played or the in-laws played, or whether even the husband is actually responsible for the marriage breakdown, I mean, without looking at those factors, the maintenance is directly awarded to a woman. How do you view this?
Yes. So in fact, I really do agree with the way you've put it, because unfortunately, there is that little bit of unfairness, I would say, if I'm not using too harsh a word, but I do think it's a bit unfair because yes, you haven't led the trial yet. You haven't gone into trial yet. So you don't exactly know. It's his word against her word. You can't really sort of prove that his family, did they really play a role? Did he really play a role in discouraging her from working or not? And yes, the maintenance does sort of get decided before you even know what went wrong in the marriage. But see, the law looks at it like it's not whether only a chaste woman is entitled to maintenance. It's not really that. It's not really about whether you've been a bad wife or a bad husband, etc. They basically award maintenance on the basis of need. But as I said, there is a lot of misuse of that today. What happens is there are lots of, I don't want to generalize, but there are lots of women who may be very sort of capable of earning, or they may have been working, they may even be earning something in cash. So, it's unaccounted for income that they are sort of having. And despite that, they will ask for maintenance either just as a pressure tactic, just to put that pressure on the husband because every month he will have to pay a stipulated amount, or it is out of spite very often that they just want him to pay even if they don't need the money. And very rarely is it actually coming from a place of need, is what I have seen. But then again, there are some cases where, of course, it is need-based, and of course, the wife hasn't been earning for like the couple has been married for 20 years, 30 years. Then, of course, it's difficult for a woman to suddenly start working. So in those sort of cases, I feel maintenance is a necessity even during the pendency of litigation. It's a must. A woman will not be able to sustain. But if people in their 30s and people in their early 40s even are sort of been married for like a very short period of time, and then you're sort of asking for maintenance right up front, it's a bit unfair, especially because you will notice lots of mothers use it as opposed to like their weapon or their tool to not give access to the kids to the fathers if they don't get enough money from the fathers. So it becomes like, oh, you want to see your child? Okay, you have to pay me XYZ amount of money per month for me, for the child, and only then will I consider letting you see the child. So that is very unfair, because it's almost like you get to see your child if you're willing to pay that extra buck, which you may or may not be able to afford.
Right. You very rightly put it, Kanupriya, where you said that maintenance, the basic premise of maintenance was to support a woman during the litigation, and especially in cases where the marriage would have lasted for a number of years, where she would have kind of not had any touch with the professional world, or it would be difficult for her to come back because perhaps the degree she would have pursued was decades ago. Now in those situations, of course, you cannot debate that till the litigation is on, of course there also you need to see whether it's the husband's fault or not. But here, we are seeing a pattern where nowadays, the younger generation, as you rightly said, they get married at 28, 30. The marriages are crumbling very fast. It could be 6 months, 8 months, within a year. And sometimes we see that irrespective of, whoever's fault it is. I mean, a basic, allegation like, I cannot adjust with my in-laws, I'm going back to my parents' home. The woman leaves, files for maintenance. Now, how fair is, the judicial system or courts to even encourage these kind of cases? Because, it's like a lifelong free income that you're entitled to.
Yes, it is. It is definitely a bit unfair, because also, what I forgot to actually mention is, see, sometimes what happens is, even if the husband has not stopped you from working, but say you have a child and the child is about 15, 18 years of age, you've been taking care of the child. So because of that, naturally, sometimes it happens that as a woman, you play a bigger role in the child's life. So because of that, you sort of work lesser hours, which is why then you sort of earn lesser. And then, okay, if you're asking for maintenance, you're asking for that compensation, it makes sense. It all adds up. That is what the law is meant for. It is meant for women who are actually in that sort of need. But what actually happens is, as you rightly said, there are younger sort of couples where the woman is very much capable of earning. She probably has been an entrepreneur of some sort, or has a good education backing her. But it's just this sort of thing that, no, I mean, I'm not going to earn, or I'm not going to work. Even if I work, I will do something in sort of the charity space. There are so many women who will actually work for NGOs, and they will work for charitable organizations, but they will refuse to take up a full-time or even a part-time job to at least partly support themselves. They will not. And that is extremely unfair, because the laws are not for the protection of those sort of women. They are for the protection of genuinely aggrieved women. But it is often misused, and it is unfair. And what happens is, even if the man has filed for divorce, everything that he is asking for becomes secondary. The first 2-3 years will go in fighting the interim maintenance, and it'll go on. It'll go on for a couple of years. If anyone is dissatisfied with the order, then you have to go to the High Court. So basically, you're only talking money. You don't go beyond that. You don't go beyond who did wrong in the marriage and who's inflicted mental cruelty. Nothing. It's basically boils down to a money game.
Right. And it also becomes very ironical when two parallel cases are running. So let's say if there is a divorce case, the woman will say, okay, I was beaten, I was thrashed, I was not given food, I was tortured. And when it comes to maintenance, incidentally, the version is very different. She would say, oh, we had the best lifestyle. So that itself, is, and you, as you said, it takes 2-3 years only to come to, some sort of an amount to be fixed, which also happens from the retrospective effect from the date when the application
exactly from the date of the application. Yeah.
Right. Now, again, we're not looking at cases even where you have kids. We are purely looking at cases where, the woman was educated. Perhaps even before her marriage got arranged. And we today see so many cases where women voluntarily don't want to take up work after marriage. Because if the husband is earning well, the husband has a job which, amounts for a lot of travel. Many women prefer not to work. They say, oh, I want to see the world with him. And when things go bad, all the blame is shifted on the in-laws. So the basic point is, how would the courts really analyze this? Do you really see courts being fair at times, or there is a lot of gender bias, and they say, oh, but she still needs to sustain, and irrespective of whoever's fault it is, the maintenance is still awarded.
So I think that's where a lawyer's role sort of comes into the picture. Like, honestly speaking, I would say that lots of times when I'm representing men, I sort of start off with this conversation where I tell them that, see, we are starting off at a back foot. Because what happens is, the sympathy of the court, or the court is going to, in most cases, the sympathy of the court is going to rest with the woman. Because, there will be a story, there will be sort of a thing that I was not allowed to work, I was not given XYZ, I was not given this, I was not given that, and the sympathy will automatically go with the woman. So as a lawyer, you have to then sort of bring that out in court. You have to bring that out that, it's not a sympathetic argument. There are lots of facts. There are lots of other surrounding circumstances which will reveal that this woman is very much capable of working, or has been working, or she's just voluntarily decided to not work, and she should not be allowed to sit at home. In fact, there are lots of Bombay High Court judgments also, not lots maybe, but there are some where the court has sort of recognized that in this sort of, on one hand, we speak of feminism, we talk of women empowerment, we talk of how we are completely capable of doing everything on our own and we don't really need sort of the man's support. But on the other hand, as you rightly said, there's like this huge contrast. Even in our pleadings, there'll be this huge contrast. There'll be one side where you're saying I was deprived of every single thing. And then on the other hand, you're saying I led such a lavish lifestyle. We had 2 holidays abroad a year. We used to travel business class. I used to go to the parlor every week, and I want that same lifestyle now. So unfortunately, yes, that does happen, and it is often encouraged also by some set of lawyers, I would say, and it does form a part of pleadings with lots of lawyers. But I think a lawyer also has to play a greater role here. And even when you're representing a woman, you sort of reason with them, and you sort of don't encourage it, and you sort of appeal to their logical and their sensible side, and you try to tell them that, I mean, there's no need to do something like this. We can fairly assess the situation and fairly decide whether or not you should be entitled to some sort of compensation. So it does take a bit of an effort, and yeah, you do sort of start at a little bit of a back foot sometimes if you're representing the man.
Right. Also, while we are, as a country, we always believe in aping laws from the West. A lot of laws when it comes to matrimonial laws have been taken from the West. But, the West is also progressive in a way, because they will have, the system is different. They will have certain fixed timelines by when the litigation ends. They also have something like
Correct.
rehabilitative maintenance, where, if the marriage is crumbling within a few years, you will have a fixed timeline by when the maintenance is awarded,
Correct.
and the woman will
Correct.
be expected to come back to the professional world and start her life again.
Correct.
Do we see
Correct.
India moving in that direction anytime soon?
I don't know if we are there yet, but I do think cases like the case which you spoke about in the beginning, there are cases like that also. There is a sort of recognition today that every woman who comes knocking at the doors of the court is not an aggrieved woman, and every woman is not entitled to maintenance, and every woman is not entitled to huge sums of maintenance. There is some sort of reasonableness that has come in, where even if maintenance is awarded in several cases, the quantum may not be that much anymore. So I think it's gradual, but it's getting there. I think there is a little bit more education about this, but it's not fully there yet. But hopefully it will be.
Right. And, do you have a message for the husbands? Because generally when we speak to a lot of men who are going through abusive marriages, they are in a bit of dilemma whether to take that call to step out, or because, there are so many threats of false cases. Like I have cases where people have filed domestic violence and divorce, and immediately they are slapped back with a 498A or a domestic violence case. So what is your message to those husbands? Should they take a stand? Should they legally prepare the ground before taking a stand, or how do they go about it?
So that's what I tell all my male clients, that you should not fear false litigation. If you should really not fear false litigation. Of course, it is time consuming and you will have to defend it to the absolute end. But you should not fear it anymore. Even whether it's a domestic violence case, whether it's a 498A, you shouldn't fear it unnecessarily if you are not in the wrong. I feel as long as you've been in the right, as long as you've not withheld anything of the wife that belongs to her, and you've not sort of kept it with you. For example, Stridhan. Stridhan is basically any jewelry that belongs to the wife. If you've not withheld it, you've not kept it with you, then there is really nothing to fear. It's just what I would advise them is that keep your accounts very sort of clear, very sort of crystal clear, in the sense that you don't falter later on. So you should keep everything very, even in terms of what if sometimes when marriages have lasted for really long, the books of accounts of the husband and wife also sort of merge. So just be a bit careful about what you do with that. And other than that, I don't think there is any need to fear false and fabricated litigation. Yes, it exists, and it exists to a very large extent. And yes, as you said, it's very often, even if the husband hasn't filed for divorce, say he's just sent a legal notice, or say he's just broached the subject of a divorce at home, that much is also often enough for women to go running and filing, 498A cases. But there's nothing really to fear. So very often people also fear their parents, because what happens is when you file a false DV case, you may often embroil the in-laws. So that sometimes, they really fear that, okay, I can handle it, but what about my mother and my father? So, but I feel if you just get good representation and you aren't actually in the wrong, you haven't actually done anything to deserve those cases, I think it's a good defense will get you sort of through. And I don't think either a man or a woman should live in an abusive marriage just out of fear of litigation.
Perfect. And lastly, before we end, Kanupriya, because you do deal with a lot of cases in a city like Mumbai, is it fair for us to generalize, because India is such a macro country, it's so diverse in the culture, and different family courts will have different kind of cases. Do you think one law for the entire nation is just, or how do we really segregate the tier 1, tier 2, tier 3 city cases?
So I think, okay, you don't mean different religions and different communities. No, your question is,
I'm saying an urban woman coming to court, an urban educated woman who has always been working, going out, coming to court for maintenance, versus somebody who is from maybe a rural area who has not really seen the world and who needs maintenance.
That distinction is sort of, it's there by practice. It's not there in the law, but it's there by practice. Like, I do feel that judges recognize that I do feel that judges understand the different sort of social, economic backgrounds that people are coming from. I feel they do recognize it. I like, again, sometimes you may have to point it out sort of very distinctly to the court, but I feel a court does recognize the different tier 1, tier 2, tier 3 distinctions, different economic social stratas. I think it is there. I think it is sort of recognized. Like, I mean, I get what you're saying, because there is a huge contrast. I mean, there'll be a sort of an urban city woman where a parlor visit will be a necessity. But I mean, there will be a woman from a village where something very different will be a necessity, like electricity bill will be a necessity. So I get where you're coming from, but I do think that even the judges do understand that distinction. I think they get it.
Perfect. And Kanupriya, I think today's conversation will limit it to this topic, but you and I have also spoken about child custody cases where you've been successful in getting custody for the fathers. And I think we leave that for a separate debate, because that's a huge topic and a lot of men follow our portal. I mean, that is a very sensitive topic that we do need to talk about some other time.
Definitely.
So yes. Thank you so much for joining us today, and wish you a very happy New Year and have a great 21.
To you as well. Thank you for having me. Thank you.
Thanks.